You're sitting on the edge of your bed in your underwear, flipping through channels after a brutal double shift, when your landlord suddenly opens the front door and walks right into your living room. He didn't knock, he didn't call, he just used his key and strolled in unannounced to check the smoke detectors. Your heart is pounding, you're completely caught off guard, and you're wondering if this is actually allowed. Let me tell you about a guy named Mike. Mike rented a duplex in Ohio. One Thursday morning, Mike was asleep after working a string of overnight shifts. His landlord let himself in with a spare key to measure the windows for new blinds. Mike woke up to the sound of a stranger rustling a metal tape measure in his bedroom. Mike grabbed a baseball bat, ready to swing, before realizing it was the property owner. Mike was furious and immediately threatened to call the cops, claiming his home had been invaded. The landlord shrugged it off, saying he owned the building and could enter whenever he felt like checking on his property. That reasoning is completely wrong, and it cost that landlord dearly. Mike ended up suing his landlord in small claims court. Small claims court is a special legal venue designed for regular people to resolve everyday disputes quickly and affordably without needing to hire an expensive attorney or navigate a massive courtroom. The judge ruled that the landlord had violated Mike's right to quiet enjoyment. Right to quiet enjoyment is a fundamental legal rule in housing that means a tenant gets to live in their rented home in total peace without the landlord constantly barging in, harassing them, or taking over the space. The judge ordered the landlord to pay Mike several $1,000s in penalties, plus Mike's court filing fees. The fact that the bank holds the mortgage or the landlord holds the deed doesn't override your legal right to absolute privacy inside those four walls. When you hand over your rent check every month, you aren't just paying for a roof. You're buying the exclusive legal right to possess that specific physical space. You legally possess the property, which means you hold possession. Possession in property law means you've the supreme, legally backed right to control who enters the space and exactly what happens inside it. When you sign a lease and take the keys, the landlord essentially surrenders their everyday authority over the physical space. They keep their title as the owner on paper, but you become the temporary legal master of the property for the duration of that rental agreement. If a landlord wants to enter the place you're renting, they almost always have to provide something called reasonable notice. Reasonable notice is a legal standard requiring the landlord to give you a fair, heads-up warning before they show up, typically 24 or 48 hours, though this specific amount of time varies heavily by state and city laws. They can't legally bypass your front door just because they hold a master key. If they want to inspect the property, fix a leaky pipe, or measure the walls, they have to act like a normal, respectful human being and schedule it with you ahead of time. Now, there's a massive difference between a routine property inspection and a true emergency. A landlord generally doesn't need to give you any notice at all if there's an active, immediate emergency. An emergency in housing law means a sudden, dangerous event that threatens life, safety, or the physical structure of the building itself. If a pipe bursts upstairs and water is actively pouring through your kitchen ceiling, the landlord can unlock the door and run inside without calling first. If a neighbor smells heavy gas, or if a giant tree branch crashes through the roof, the landlord can bypass the notice rule because human safety and structural preservation outrank your temporary privacy. But fixing a leaky faucet, checking the smoke detector batteries, or measuring the baseboards don't qualify as emergencies. Those are standard, planned maintenance tasks, and they legally require advance notice every single time. Sometimes, landlords try to get sneaky about this. They might slip a tiny note under your door on a Monday morning that says they'll be entering on Tuesday at 9 in the morning. You might think that counts as notice, but in many states, it actually doesn't count as proper notice at all. However, many states have very specific criminal statutes against criminal trespass. Criminal trespass happens when someone knowingly enters or stays in a property without any legal right or permission to be there. If you've explicitly told your landlord they aren't welcome without proper notice, and they barge in anyway, some local police departments will actually issue a citation or arrest them, treating the landlord just like any random stranger off the street. You might be wondering about the absolute easiest, most old-school way to stop someone from walking through your front door. Can you just put a chain lock or a deadbolt on the inside of the door? Yes, you can usually install a privacy lock for your own safety, but you generally can't permanently change the locks without giving the landlord a working copy of the new key. Altering the locks without permission can actually put you in breach of your own lease. If the landlord can't legally access the property during a genuine emergency because you locked them out with a heavy deadbolt, you could be held legally liable for the property damage. You're legally allowed to protect your privacy, but you can't legally block emergency access entirely. Instead of acting out of anger, the absolute smartest way to handle a boundary-crossing landlord is to establish a paper trail. If they walk in unannounced, immediately send a polite, firm text message or an email that says something straightforward. You need to clearly state that they entered the property without giving proper notice as required by state law, and you formally request that they provide written notice for any future visits. If you ever have to go to court like Mike did, you want undeniable proof that you explicitly warned them. If they completely ignore your written warning and keep barging in, you're stepping into a territory where you might need professional help. Some states allow you to legally break your lease and move out without any penalty if the landlord repeatedly violates your right to quiet enjoyment. This is legally known as constructive eviction. Constructive eviction happens when the landlord's severe actions or their failure to act makes the property legally uninhabitable or completely strips you of your basic right to privacy, essentially forcing you out of your home against your will. If you successfully claim constructive eviction, you can legally pack your bags, leave the property, and completely break the lease without owing another dime of rent. You might also be able to sue your landlord for monetary damages in small claims court. Remember Mike from the beginning of this story? He didn't just get mad and yell, he documented the incident, he kept all his text messages, and he forced his landlord to pay actual financial penalties for invading his privacy. You can't just walk into a courtroom and complain that your landlord is annoying or inconsiderate, though. You need concrete proof that the violation occurred. Save every single text message. Keep every single piece of paper they tape to your door. If you have a cheap security camera pointing at your interior living room, that video footage is absolute gold in a legal dispute. A judge wants to see clear evidence that the landlord entered your private space without giving the legally required amount of notice. If you're dealing with a landlord who simply refuses to respect your boundaries, or if you're actively considering breaking your lease because you feel entirely unsafe in your own home, it's time to consult a local attorney. Tenant rights vary drastically from one city to the next. A local lawyer who specializes in landlord-tenant law will know the exact, specific notice requirements in your exact zip code, and they can quickly tell you if you've enough hard evidence to successfully break your lease or sue for damages. Nobody should ever feel trapped or exposed in their own home. Knowing your rights as a renter is the absolute best way to make sure the person collecting the rent check doesn't start acting like they sleep in your bed. When you pay for your own space, you buy your own absolute privacy. The law fully recognizes that, and the system firmly backs your right to tell them to stay out until they follow the rules. Has a landlord, a maintenance worker, or a property manager ever walked into your home without giving you proper warning first? Tell me exactly how you handled the situation in the comments below. If this breakdown helped you understand exactly how your tenant privacy rights work, pass this video along to a buddy who might be currently stressing out over a nosy landlord right now. Make sure you subscribe to Scribble Law so you always know the actual rules of the game before the legal system tries to blindside your wallet.